Amar Correa, Advocate, High Court of Karnataka. Sir, it's a pleasure to have you with us today. Welcome to the webinar.
Thank you very much,
Great,
Vikram.
with great pleasure. Now I would like to introduce our today's speaker. In fact, it's a very brief introduction. Amar started his practice in the year 2000 under the aegis of Sri B.V. Pinto. He also worked under senior advocate Sri Anant Mandgi. He set up his independent practice in the year 2002. He has vast exposure in conducting sessions trial. He had handled matters relating, he is handling matters relating to mining, Ndps, Foreigners Act, financial frauds in high magnitude. He regularly appears before the CBI courts. He has appeared as a special public prosecutor in cases of public importance. He has also assisted courts as amicus curiae in many cases. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you. Thank you very much, Vikram. And we should just congratulations to you on the good work that you have been you had commenced long time back, and you're carrying on the same thing all through these many months. Please keep up the good work as such. Now, as far as the Ndps Act is concerned, we are all aware generally that the provisions or the enactment itself as such is quite stringent in nature, and the introduction of this law, the Ndps Act of 1985, it was meant to be stringent. A very brief background, without going into too many specifics on this, is prior to the 1985 Ndps Act, the earlier original act, which were the central acts governing the offenses or violations in relation to drugs and narcotics, were two acts. One was the Opium Act of 1857, and the other one was the Opium Act of 1878. In fact, there were large amendments made therein. And also the other act was the Dangerous Drugs Act 1930. Now, over a period of time, it was seen that the illicit trafficking in drugs is rampant. This was seen not only in India, internationally as well. And at that point of time, there was a need felt. Firstly, that there was all the essentials, there were all necessities to curb this menace, which was peddling in drugs, because it affected, it was considered, and it is considered, and it does, in fact, affect the society at large. Apart from that, even the international peddling at such point of time was also gaining more scope. There were innovative methods. The new drugs came to be introduced. And at such point of time, the need was felt that very stringent laws were to be enacted in India as well. And the certain other reasons that led to this stringent provisions to be introduced were that the punishment was understood to be non-deterrent. The punishment at such points of time were only 3 to 4 years of rigorous imprisonment. So that was termed as not sufficient. It was not acting as the intention was, which was to deter. Secondly, the need was felt investigation powers need to be diversified to various other empowered officers or other agencies as well. Thirdly, around the same time, India became a part of a few international treaties And lastly, as I said earlier, when it was seen that newer drugs have been come to be introduced and newer drugs are, people are getting addicted to newer drugs. Hence, the need was felt to introduce this stringent act, which was initially the Ndps Act 1985. Pursuant to that, there was another amendment which was in 1989, and an amendment to a little larger or greater extent, which were two in numbers, which was one in 2001 and the other one was in 2014. Around the same time, there was introduction also of the Ndps, as it is termed, which is prevention of immoral illicit traffic in narcotic drugs. The intent therein being that the offenders as such should not be allowed to bear the fruits of their illegal activities. So with this background is the present Ndps law that is in force with all the seen stringent provisions of such. Now, while I'm dealing with the contours of the Ndps Act here, I would just phase it into 5 particular sections or categories. Firstly, being the jurisdiction of the courts, the magistrates or the special courts. Secondly, is the investigation, powers of investigation, and also the requirements that are to be taken care of while conducting investigation. Thirdly, the provisions in relation to the bail. Fourthly, the trial and the presumptions that govern certain offenses under certain circumstances. And lastly, which is a relatively smaller issue, which is the appeal. Now, firstly, when it comes to the jurisdictions of the courts, the magistrate or the special courts. Now, the section 36 of the Ndps Act provides for the establishment of the special courts. Wherein this provision provides basically that the special courts would be established for trying offenses under this act, for which there needs to be a notification in the official gazette. So that there may not be a need for me to go any deeper into that. The next thing is section 36A and the subsections therein, which would attain some importance as such. Now, section 36A provides that the offenses under the Ndps Act are to be tried by the special courts. Now, whereas section 36A, subsection 1B, this I will just read this. I will just read the subsection there, where a person accused of or suspected of the commission of an offence under this act is forwarded to the magistrate on the subsection 2 or subsection 2A of section 167 of the code. Such magistrate may authorize the detention of such person in such custody as he thinks fit for a period not exceeding 15 days in the whole, where such magistrate is a judicial magistrate, and 7 days in the whole, where such magistrate is an executive magistrate. Again, the bare meaning of this is only that a remand of an arrested accused essentially still remains under 167 of the Code of Criminal Procedure. Once the said magistrate, the said accused is present, he is produced before the jurisdictional magistrate. In such an event, the powers of the magistrate as such is confined to remand for a maximum period of 15 days alone and not more than that, when the said magistrate is a judicial magistrate. And when the said magistrate, under certain very grave circumstances, when there is a need to produce such an accused before an executive magistrate, then the powers of such executive magistrate is only for a period of 7 days remand, not more than that. Now, again, the next provision therein says that basically it means that once the concerned magistrate feels that there is no necessity for any such remand of police or where a decision in respect of his further remand is not necessary, in that event, the said accused will have to be forwarded to the special court immediately thereon. Now, again, this is something which is more on a jurisdictional issue as such. Generally, none of these would inure to the benefit of the accused, or also it would not affect the prosecution case as such, if at all there are any kind of anomalies here or non-compliances here. However, the next provision that is necessary to be seen is Section 36A subsection, Section 36A3. Now, Section 36A3 reads, nothing contained in this section. Now, I would not read the whole thing there. What is meant by this provision is the powers of the High Court in respect of bail can be exercised under Section 439 as well. Meaning thereby, other than Section 37, which is a specific provision provided, powers of the High Court can also be invoked under Section 439. And the next important thing, which I would term as a necessary and important provision, is Section 36A subsection 4. Now, let me read that. In respect of persons accused of an offense punishable under Section 19 or Section 24 or Section 27A, or for offenses involving commercial quantity, the references in subsection 2 of Section 167 of CRPC, thereof to 90 days, where they occur, shall be construed as reference to 180 days, provided that if it is not possible to complete the investigation within the said period of 180 days, the special court may extend the said period up to 1 year on the report of the public prosecutor indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days. Now, to briefly explain this, we are all aware, like firstly as I submitted, the remand even under the Ndps Act is under Section 167 of CRPC itself. We are aware that when it comes to offenses that are punishable up to 10 years, in general law, in such an event, the maximum days for remand, pursuant to which there cannot be a continued remand without cognizance taken, is 60 days. And when it comes to offenses which are punishable with 10 years, more than 10 years, under such circumstances, the remand is for 90 days. Now, what Section 36A subsection 4 provides? Now, it only replaces the word 90 days with 180 days. Thereby meaning that now this is not for all the offenses under the Ndps Act. Now, this provision is applicable to only offenses that are grave in nature. Now, let's say, if at all we have to read what are the specific provisions. These are, now I would rather rephrase this. When would it be right or legal for the concerned courts to remand an accused to a period of 180 days is where there is offense punishable under section 19 or section 24 or section 27A or for offenses involving commercial quantity. Now, to explain here, again in very much brief, is it is only in serious offenses would there be a remand for a duration of 180 days without there being a completion of investigation, without there being a final report filed. Beyond 180 days, there cannot be a remand without there being a final report filed, as I said earlier. And this is only in offenses that are very serious in nature. Now, as you all would be aware, the bifurcation of the gravity of offenses under the Ndps Act is always based on the quantity. Now, this provision specifies here commercial quantity A, which primarily is the gravest offense in Ndps cases, and also the offenses under section 19, 24, and 27A. Meaning, these 19, section 24, and 27A are also considered as grave offenses. For these offenses, there can be a remand without cognizance, or there can be a remand without a final report up to a duration of 180 days. And pursuant to that, from the 181st day itself, the accused would be entitled for a statutory bail if there is no final report filed as on such date, A, and in the event there is no application under the next proviso of section 36A, subsection 4 of Ndps Act, which is where the investigating officer makes an application before the jurisdictional special judge. And with that, he submits his report indicating the progress of the investigation made and thereby satisfies the court that this is the progress in investigation which has been made till now. And if at all, and for this reason, for these reasons as such, I am not able to conclude my investigation within this stipulated period of 180 days. And hence, I am requesting, or I am making a prayer that the investigation duration may kindly be extended beyond 180 days, and that another duration that the investigating officer is entitled to, if he satisfies the court, is another 180 days, thereby meaning that there can be a remand of an individual or an accused to in judicial custody for a duration of 1 year from the first date of his arrest and remand, in the event there is, despite the event of there not being a final report by way of a charge sheet filed, or for that matter, there not being cognizance of the offense taken. Now, this gives us an insight as to the seriousness of this legislation. Now, of course, it goes without saying that there are similar provisions in other acts as well. UAPA we had the earlier TADA, and there are some other acts as well, which are the special enactments for offences which are grave in nature. COPA has a similar provision as such. So, given this, it is necessary for us to know that a remand of an accused can be up to a period of 1 year, initially for 180 days, it can be extended up to a total period of 1 year without a final report filed. Now, a very recent judgment of the Bombay High Court law, I could not lay my hands on the citation. It's in fact just very recently laid. It says that if at all the investigating officer fails to give proper reasoning, or if he fails to indicate to the court as to what is the progress of investigation he has made in the already conducted investigation for the first 180 days, if he fails to satisfy the court, or if he fails to report to the court that this is the progress I have made, in that event, the concerned court would consider his application, would consider release accused on bail, which would be a release on statutory bail. So to this extent, we will understand well the stringent provision that is there as far as the remand of an accused is concerned. Now, this apart, again, section 36C is more of a general provision, which basically applies the code to all the proceedings before a special court. Thereby meaning, again, as I said earlier, that section, I think the entire procedure as such, procedure of trial before the concerned jurisdictional court, is governed by the Code of Criminal Procedure. So with this, the primary jurisdiction, or the primary aspect of the jurisdiction of the special courts, as far as offenses under this act, I would conclude that. Now, the next stage I would go to is the investigation of offenses under the Ndps Act. Now, the subject as such of the provisions in law in respect of investigation, the technicalities that are involved in respect of investigation, in respect of the remand, are very stringent here. They are quite technical, and many a times, as we are all aware, it is the technical grounds on which either bail is sought, or it is the technical grounds on which even there would be an acquittal sought. The underlying principle for this is always, as is applicable in general law, which is the graver the punishment, more stricter is required the compliance of the provisions of law. If something under this act, under the Ndps Act, is required to be conducted in a particular manner, it requires to be conducted in a specific manner itself, failing which the benefit has to inure to the accused. Now, before I touch into any specific provisions in respect of investigation. Now, investigation generally commences from section 42 of the Ndps Act upon receipt of a information. What happens? What happens upon receipt of an information when the offense is alleged to be taking place or to have been taken place in a public place? At what point of time? Dusk to dawn or dawn to dusk? Sunrise, which thereby meaning sunset to sunrise, wherein that's a specific provision provided there. And it also goes to the extent of where are you conducting the search? Is the investigating officer conducting the search on the body of the individual? Is he conducting a search of something that is attached to the body of the individual? Is he conducting a search of the house of the individual or the vehicle of an individual? All depending on the specific facts and circumstances of the case, as alleged by the investigating agency in the charge before the court, or the facts of the case as is charged against the accused, would there be necessity for compliance of these provisions? Now, but before that, one important law, which I would rather prefer to take a little pain before going to the specifics, and which primarily is one of the latest judgments of the Honorable Supreme Court. Many would be aware that as late as in 2018, in the case of Mohanlal versus State of Punjab, which was on a reference to a 3-judge bench, this larger bench of the Honorable Supreme Court laid down that in the event the first informant himself takes up or continues the investigation in the case and files the final report, in that event, his entire investigation has to get vitiated, has to be termed as vitiated for the reason that it would cause, or it is deemed also to be causing prejudice to the accused. Now, in this judgment, which is reported in 2018, 17 SCC, page 627, this 3-judge bench held that such investigation would be termed as tainted. The complainant himself cannot be the investigating officer. Thereby meaning, let us say there is a suo motu complaint by the raiding officer and he himself continues the investigation. He cannot do so because he is going to stand by his raid, he is going to stand by his investigation comments, and ultimately he is by all means going to file a final report by way of a charge sheet against the accused. This was the principle or the pretext under which the Honorable Supreme Court on a reference laid that this is not acceptable. All such investigations that has culminated into a charge sheet on which the accused are charged have to be vitiated, thereby resulting in acquittal of the accused. In fact, the Honorable Supreme Court went to the extent of even saying that the benefit of this judgment would only be to cases which would be after this judgment and not the earlier judgment. Now, what happened after this was the fact that in majority of the cases, it is the investigating agency or a particular officer that receives an information and he takes up the raid, he conducts the raid, he becomes the first informant and he goes on with the investigation as such and lays the charge sheet. Now, in a subsequent case, which is in the case of Mukesh Singh versus State, NCB, there was doubt expressed in respect of this judgment, laying down that the informant cannot be the investigating officer himself, and even if it does, that cannot inure to the total benefit of the accused, and the said judgment came to be referred to a constitution bench. Now, and thereby the constitution bench in the case of Mukesh Singh versus State by the NCB reported in 2020 SCC online Supreme Court page 700, thereby held that this law as laid in Mohanlal versus State of Punjab is not a good law, to the extent, to only the extent that it cannot be said that merely because the investigating officer himself is the first informant or was the first informant, that itself automatically vitiates the investigation done, and that itself automatically cannot inure to the benefit of the accused. What the Honorable Supreme Court therein said was, there is a need for the accused to show that because of this, wherein because of the background that the first informant police officer himself conducted the investigation and laid the charge sheet, it has to be shown that this particular action of the police officers or the investigating agency has caused bias or great prejudice to the accused. Only and only in such circumstances would there be any benefit that can be extended to the accused as such, and it cannot be said by rule that every such investigation has to fall. So, and also what the Honorable Supreme Court therein did was referring the Constitution bench in Mukesh Singh versus State NCB. It was also clarified therein that all the judgments which were passed earlier, wherein the informant being the investigating officer has inured to the benefit of the accused where the investigation has vitiated, those judgments were termed as typical to the facts of the said case, and it cannot be termed as general. So given this, the present scenario as such, now the reason why I am stressing on this is to indicate as to the extent of gravity, the extent of seriousness the Honorable Supreme Court is giving to cases under the Ndps. Now, the law as such is about, of course, when it comes to the trials of these cases, we ought to know that all these trials and final judgment, rather, all these technicalities always inure, majority of the times, inure to the benefit of the accused, but going by the principle that more stringent the provisions of law, more graver is termed as the offense, there ought to be more compliance as far as the procedural aspects are concerned. Now, when it comes to the investigation, the powers of investigation, I would specifically touch on 3 sections here, which is Section 42 of the Ndps Act, Section 43, and Section 50. Now, what does Section 42 say? I would not want to read the whole provision of it. Section 42 basically refers to conducting of the search and seizure by the concerned police officer. Section 42 in its first part specifies certain police officers. I would not read that. Let me read the subsequent portion. Now it says, if he has a reason to believe from personal knowledge or information given by any person. Now this is important, and taken down in writing that any narcotic drug or psychotropic substance or controlled substance in respect of which an offense punishable under so and so is concerned. And it further refers to is kept or concealed in any building, conveyance, or enclosed place. I will directly come to the applicability of Section 42. In short, the applicability of Section 42 is one, when there is an information received by the authorized officers of any offense or of any contraband or for the matter of any illegality in respect of these offenses under the Ndps Act, not in a public place but in a private place. So the requirement here is when such an information is received of offenses being conducted, or that if a raid is conducted, there could be a seizure made, or if there's raid conducted, then the same would reveal certain contraband. If such an information is received in respect of a private place, in such an event, it is essential that the investigating officer reduces such information into writing forthwith. Now, this is termed as a very much necessary provision of law, failures of which has even resulted in the courts holding that this provision has not been sufficiently complied with. Now, once this information is received in respect of a private place, then what has to be done? I'll just read the last part there. Is kept or concealed in any building, conveyance, or enclosed place may, between sunrise and sunset. So between sunrise and sunset, if he has entered into and search any building, conveyance, or place, and there are certain procedures laid on there. In such an event, it is essential that this information has to be taken down in writing. Now, the next important provision, which is subsection 2 there, says where an officer takes down an information in writing under subsection 1 or records grounds for his belief under the proviso thereof, he shall within 72 hours send a copy thereof to his immediate official superior. Now, like I submitted, it is mandatory that the information received has to be taken down in writing in certain cases. The next thing is this information within the next 72 hours has to be sent to his immediate superior. Now, one important judgment in respect of this is in the case of State of Rajasthan versus Jagraj Singh, reported in 2016 11 SEC, page 687. Now, I'll just pause here for a moment and come to the need of these stringent provisions here is because of a presumption in law. Because of the presumption in law that is available favoring the prosecution against the accused, these stringent provisions have to be complied with. Now, in this judgment, which I said, is State of Rajasthan versus Jagraj Singh, what the Honorable Supreme Court laid, or the conclusions of the Supreme Court here, was that there is inconsistency in the information written down by the police officer who received the information, which information is written down for compliance of section 42(1). And this inconsistency is in comparison with section 42 subsection 2, which is in respect of forwarding such information received to his immediate superior. Let me elaborate this a little. The Supreme Court holds here that the information written down by the police officer under 42(1) is different, and the information forwarded to his immediate superior under section 42 subsection 2 is different, and hence there is no compliance of section 42. These provisions are so very important to the extent, in fact, in this judgment, going further, the Honorable Supreme Court also holds that the recording of the information by the investigating officer was here that he has reasons to believe that he has to conduct a raid between sunset and sunrise. So when such a raid has to be conducted, he has to record therein that there is reason to believe that the accused is going to escape. If I have to go, I have to rush to the spot immediately. Otherwise, the accused will escape. There is no need for compliance of section 41 of the Ndps Act getting a warrant, and hence the Supreme Court holds that there is non-compliance of this proviso also. Thereby, this merely on the ground that there is inconsistency in recording the information and forwarding the information, the Supreme Court concludes that there is no sufficient compliance and thereby acquits the accused. Another provision, another judgment in respect of section 42 is S.K. Raju versus State of West Bengal, reported in 2018 9 SEC, page 708. Now, this much in respect of section 42. Now, I would just, without reading section 43, section 43 refers to a similar raid or a similar search and seizure of a place which is termed as a public place. The provision heading reads, power of search and arrest in public place. So basically it says, how should it be construed when information is received in respect of an offense which could be unearthed or there could be a seizure and arrest made in a public place. Now, the next provision in respect of the search and seizure, which again is a very important provision, is section 50 of the Ndps Act. Section 50 of the Ndps Act lays down conditions when it comes to conducting a search of a person. Now, the important thing in this provision is, let me just read the subsection 1 there. When any officer duly authorized under section 42 is about, I'll just leave that, he shall, if such person so requires, take such person without unnecessary delay to the nearest gazetted officer of any of the departments mentioned in section 42 or to the nearest magistrate. If such requisition is made, subsection 2, if such requisition is made, the officer may detain the person until he can bring before the gazetted officer or the magistrate. Then I think there are other provisions in respect of search of a female officer and so on and so forth as to the procedures. Now, the necessity here, as far as section 50 is concerned, is when the search of the body of an individual is concerned. In such an event, the raiding officer or the investigating officer has to specifically convey to the concerned accused that you have a right to opt to a search of your body before a gazetted officer. Now here, there are certain important technicalities which are required to be understood and appreciated. What involves the body of an individual? Now, the judgments of the courts go to the extent of saying that if in the body or if a person is holding a bag in his hand on his shoulder and the investigating officer is required or needs to search his bag, then that bag does not become a search of the body of the individual. There is no compliance required for section 50 wherein the right has to be explained to him. If the same search is to be conducted in his house, if such a search has to be conducted in his vehicle, which is a private vehicle, again, the judgments of the courts would say that there is no need to apprise, there is no question of such a right existing to the accused of such. Now, this judgment in respect of what is a personal search, I would just give one latest judgment in this respect. What is a personal search? What is a search of the body of the individual? When it is a vehicle, private vehicle, or a public, when it is termed as a private place or a private vehicle. The judgment in the case of State of Punjab versus Baljinder Singh, reported in 2018, 2018, volume 18, SEC, page 540. Baljinder Singh judgment is reported in 2019, 10 SEC, page 473. And there is another judgment on similar lines, which is Mohinder Singh, judgment in the case of Mohinder Singh, which is 2018, 18 SEC, page 540. these judgments, again, while they say the necessity of compliance of section 50 when it comes to search of the body of a person, but when it comes to search of something attached to his body or search of a private vehicle, there is no requirement of compliance of section 50 as such. So given this, now as far as investigation is concerned, now these are the primary aspects which the investigating officer needs to bear in mind while investigation is conducted, failing which the accused would always be entitled to take benefit of it. Now, the third aspect is going into the next stage of a proceeding as far as offense on Ndps case is concerned, which is the provisions in relation to bail under the Ndps Act. Now, the bail provision is under section 37 of the Ndps Act. Section 37 of the Ndps Act is very vital in offences involving commercial quantity and also offences involving section 19 or section 24 or section 27A. Now, I had referred to these sections and commercial quantity earlier while referring to section 36A subsection 4, which is in respect of remand of an accused to a period of 180 days or more up to 1 year. Now, the bail provision also is drastically stringent when it comes to section 19 or section 24 or section 24A, and also all offences involving commercial quantity. Now, section 19 as such relates to basically offences in respect of opium cultivation. Section 24 relates to 24 to 26 relates to section 24 to 26 relates to yes, offences, punishment for external dealings in narcotics, drugs, and psychotropic substances. That's what section 24 deals with. And lastly, section 27A is financing and harboring an accused. So these offences are termed as serious in nature along with all offences involving commercial quantity. Now, the bail provision here is this commences with a non-obstante clause, which says, subsection 1 of 37 says, notwithstanding anything contained in the Code of Criminal Procedure. A, every offense punishable under this act shall be cognizable. That's okay. B, no person accused of an offense punishable for offenses under section 19 or section 24 or section 27A, and also for offenses involving commercial quantity, shall be released on bail or on his own bond, unless, firstly, the public prosecutor has been given an opportunity to oppose the application for such release. There may not be so much of a problem in respect of that. Secondly, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit an offense while on bail. Now, a reading of this provision, this second condition therein, where the court has to have reasonable grounds to believe that he is innocent. Secondly, the court also would believe that he will not commit offenses while on bail. Now, I think it goes without saying that a conclusion of this nature is almost impossible, for the reason that the court almost has to come to the conclusion that the accused is absolutely innocent, or the court has to come to a conclusion that there is absolutely no prima facie case itself made against the accused, or the court has to almost come to a conclusion, if I have to loosely put it, that it is as good as a case for quashing. Now, perhaps there might be a very slender difference that will lie between what could be termed as a prima facie case or existence or non-existence of a prima facie case. Existence of a prima facie case would not allow a court considering a bail application to say that I have grounds for believing that he is not guilty. Non-existence of a prima facie case would as well empower the court to come to a conclusion that this is a case for quashing and there is no point in going into a trial against the accused. So this, in fact, we are aware that similar provisions are there in other enactments. For example, we have a similar provision under COCA, and also corresponding similar acts of these other states, which is of the Maharashtra court. We have MOCA. We have similar provisions under UAPA. We have similar provisions. We had similar provisions under the Prevention of Money Laundering Act. Now, a judgment in the case of Nikesh Tarachand Shah versus Union of India of the Honorable Supreme Court, reported in 2018, 11 SCC, page 1, has struck down Section 45 of the Prevention of Money Laundering Act, which provision, Section 45, was corresponding or similar to Section 37 of the Ndps Act. The Supreme Court had come to a conclusion therein, like whatever I discussed just now, that such a provision would as well cannot entitle an individual for bail, and hence this provision, this kind of an enactment cannot be sustained in law. Now, another judgment of the Honorable Supreme Court, again very recently. Now, what would happen when it comes to bail? When it came to bail under the Ndps Act, in majority of the cases, there was another judgment of the Honorable Supreme Court, which is Michael Raj's case, wherein the Honorable Supreme Court had held about the qualitative report from the Forensic Science Laboratory, which would indicate the purity content of the narcotic. Like, for example, let us say there is a mixture of a contraband. It is to be assessed by the Forensic Science Laboratory as to the chemical examiner there. What is the content of purity of the narcotic and what is the other content or impure content? And the quantity to be contemplated as small, intermediary, and commercial will be only based on the qualitative report or the purity content and not the rest of it. Now, this judgment in Michael Raj again was referred to a larger bench, and in a very recent judgment on reference, in the case of Hira Singh versus Union of India, the reported in 2020 SEC online SC page 382. The Honorable Supreme Court has come to a conclusion, or the Honorable Supreme Court has held that the case of Michael Raj cannot be termed as a good law, henceforth. Meaning thereby that the whole quantity as such will have to be termed or will have to be taken into account while calculating whether it is a small quantity or an intermediate quantity or a commercial quantity. Now, when it comes to bail provisions, the one judgment of the Honorable Supreme Court, which appreciates as to what is reasonable grounds as contemplated in Section 37 of the Ndps Act, wherein subsection 1, the second provision there, where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that the accused is not guilty. Now, what is the meaning of this reasonable ground? He is explained by the Honorable Supreme Court in the case of Union of India versus Shiv Shankar Kesri, reported in 2007, 7 SCC, page 798. Now here, the reasonable ground, in fact, the courts even go to the extent of saying that if the court feels that there is no reasonable chances of there to be said that there might be a likelihood of a conviction, in such an event, it can be termed as reasonable ground to hold that he is not guilty of the offense. Now, one judgment in respect of this is the recent case which came up from Bombay in the case of I think the series of cases involving the alleged suicide of Sushant Singh Rajput, wherein wherein his friend Reha Chakraborty was arrested for the offense under the Ndps Act. The offences alleged therein against Reha Chakraborty included the offense under Section 27A of the Ndpx Act, which was financing and harboring. The Bombay High Court came firstly the
I've just lost the connection. I think Mr. Amar Correa will be rejoining us.
Vikram, can you hear?
Yes, sir. I'm able to hear you.
Very, very sorry.
No problem.
Yeah, I'm just on the concluding part now. So this judgment in the case of Reha Chakraborty, of course, laid down the law that reiterated the law that all offences under the Ndps Act are non-bailable in nature. And apart from that, it also laid down that offence under Section 27A, which is financing and harboring, does not include in itself somebody advancing money for another individual to consume drugs. So I think going by whatever the news reports are there, and even going in the judgment as such, the allegation against Rhea Chakraborty was that she had paid money to Sushant Singh to procure the drugs for his consumption. And thereby the investigating agency said that there are that itself amounts to offense under section 27A of financing and harboring. Now the Bombay High Court holds that giving of money to consume drugs to an individual cannot be termed as financing or harboring for the purpose of trafficking. So these stringent provisions as far as bails are concerned are what presently govern. But of course, again, the courts very many times lay down that when a prima facie case is not made out against the individual, definitely yes, it would entitle the accused for a bail. There are judgments which have also said that if there is non-compliance of section 50 to a great extent, even then that has to entail the accused for the benefit of bail, primarily for the reason that such non-compliance is going to inure to his benefit at a later point of time, at the time of appreciating the matter on the merits. There are other judgments also which would say that merely non-compliance of these stringent provisions would not entitle an accused to bail, and these will have to be looked into at the time of trial. Now, just the last aspect which I would want to touch again is when it comes to trials, there is a presumption. Now, the reason why these provisions are construed as very seriously to be followed in letter and spirit, there has to be substantial or total compliance of it, is because of section 35 of the Ndps Act, which is the presumption of a culpable mental state, which basically means where an offense as such, as defined, requires there to be a mental state of the accused, of his possession, then it shall be presumed in law that the accused had, he was in conscious possession, that he had a culpable mental state. This is what has been, this is what section 35 states. Now, a very necessary, a very important and very enlightening judgment on this is the judgment in the case of Noor Aga versus State of Punjab, reported in 2008, 16 SEC, page 417. Now, again, this presumption operates in such a way that the prosecution at some point of time gets the benefit of presumption, and thereby the reverse burden against the accused would apply. Now, given this, what the Honorable Supreme Court says is that firstly, before applying section 35, which is the presumption, there has to be conclusive foundational requirement laid by the prosecution or proved by the prosecution to establish that he was in possession, firstly. And this is required to be proved by the prosecution before applicability of the reverse burden. The reverse burden proof is applicable even in offense under section 138 of the NI Act. There is, including there are certain other provisions or certain other enactments also. So this reverse burden, before its applicability, there is a necessity that certain basic facts are required to be fulfilled or established totally by the prosecution. Now, the reason for this again is that it is a human right of presumption of innocence of every individual. This presumption of innocence of an individual is not constitutionally given as such. No, it is a human right, which is a presumption of innocence. And to overcome that, or to commence with a presumption against the accused, there has to be certain foundational facts established by the prosecution. Only then will there be a reverse burden that would be applicable. Again, the basic principle in all criminal cases is that the prosecution is required to commence with the innocence of the accused, and there cannot be commencement of a trial that the accused is termed as guilty. One provision here which comes to my mind is Section 39 of the POCSO Act, which perhaps which has been challenged several times now, which says that merely filing of a charge sheet for certain offenses would be sufficient to term that the accused is guilty of the said offense, and it is a burden on the accused to prove that he is not guilty. Now, even in that case also, the courts have explained that all said and done, the initial burden on the prosecution, which is to establish basic foundational facts, that cannot be escaped with by the prosecution. Now, also to that extent, the strict applicability of this initial burden, or the strict applicability of establishment of basic facts before applying reverse burden, is a judgment in the case of Gorakhnath Prasad versus State of Bihar, reported in 2018 to SEC page 305. Now, one important, which I would say are the most important judgment, and which is the latest judgment that the Honorable Supreme Court has delivered, which would again definitely, presently at least, be termed as a very landmark judgment, is the case in Tofan Singh versus State of Tamil Nadu. Now, Tofan Singh versus State of Tamil Nadu was a case which was referred to a larger bench of the Honorable Supreme Court. Now, there are very important questions that were raised, and I will just directly go. Of course, this judgment was on a reference, and the judgment ratio is 2:1. The question directly raised by the question directly taken up by the Supreme Court for being answered is whether an officer empowered under Section 42 of the Ndps Act and or the officer empowered under Section 53 of the Ndps Act are police officers, and therefore statements recorded by such officers would be hit by Section 25 of the Evidence Act. Secondly, what is the extent, nature, purpose, and scope of the power conferred under Section 67 of the Ndps Act available to and exercisable by an officer under Section 42 thereof, and whether power under Section 67 is the power to record confession capable of being used as substantive evidence to convict an accused. So the Honorable Supreme Court here comes to the conclusion that the officers empowered under the Ndps Act to conduct an investigation need to be termed as police officers, and thereby the statements under Section 67 recorded by these officers cannot be, will have to be essentially hit by Section 25 of the Evidence Act, meaning thereby that it will have no evidentiary value. This is a very important development. This is a very important and a necessary judgment for the reason that irrespective of it being a state police or it being any other officers that have powers of arrest, search, and seizure. The necessity is to see the circumstance under which the accused makes a statement. If it is under fear, if there is amenability of any kind of a torture, compulsion, coercion, or threat, then essentially such officers need be termed as police officers, and thereby such statements recorded in Section 67 of the Ndps Act will essentially have to be hit by Section 67, by Section 25 of the Evidence Act, and hence these officers essentially will be termed as police officers for the purpose of Ndps Act. The minority view in this judgment may not be necessary though for us to go into. And lastly, just when it comes to what happens in an appeal, of course, all these provisions relating to bail, all these provisions relating to suspension of sentence and bail are applicable as a hindrance to the accused, even at the time of at the appellate stage also, except for the fact that there is more definite evidence available for the accused to argue why there is no prima facie case made out, and why it can be termed that there are reasons to believe that he is not guilty of the offense. So with this, I conclude this topic on the contours of the Ndps Act.
Thank you, sir, for our enlightening session. Now, with your permission, we will move on to the Q&A session. Can we have the first online question, please? I repeat, can we have the first online question, please? All right, we'll start with, all right, I see Mr. Harish raising his hand, but somebody else. All right, we'll start with Mr. Harish. Yes, sir, you are unmuted.
Good evening, Trivikram. Good evening. Excellent overview of the Act. See, the objective of the Act is prevention and detection, basically under the Ndps Act. After 35 years, do you think this Act has been successful in preventing drug abuse, illicit trafficking of drugs, and detection and differentiation of natural drugs versus the synthetic drugs?
I think sir is muted. I am unmuting you, sir.
Okay. Sir, yes, I totally agree, sir. I think we are seeing lots of this happening now of late. Let's say over a period of a few months now. To a great extent, yes, sir, we are convinced that the intent of the legislation is being is being implemented more strongly of late. I totally agree. But at times, what happens for us is when we go into more deeper aspects of the Act, it is a good thing. I agree. I would only not want to stop at that. I would only say that there has to be more rigorous or vigorous approach by the investigating agency to go to the root. You see, sir, the powers that are there for the investigation are drastic. In a way, we could term it as good. Yes, they are required to be there. But at times we feel that it should not be that they stop at certain people. The investigating agency is required always to go to the root of it. But the best thing is, yes, there is a commencement and there is nothing taking away from them as far as that is concerned. I totally agree with you on that, sir.
Don't you think that the Act is followed more in its breach than in its compliance, and leading to give room for more of Pablo Escobars in this country? Colombian drug lord.
Yes, sir. Escobar, I think we are taken with Escobar's life from the series that we have seen. I suppose
now it is there on the Netflix, I think, or Amazon.
Yes, I think, and we know from that particular series that has been streamlined, the extent to which Pablo Escobar was also protected by the powerful individual.
Powerful.
Everybody as such. Everybody.
He could bring down the government also. In fact, there was a bid by him to bring down one of the governments
Yes,
in
yes,
one of the countries where he was operating.
absolutely. And I remember seeing there was a recent photo of Pablo Escobar, which was being published in or circulating in social media, where at a time he was wanted by the CIA. He stood in front of the White House and a picture was taken in front of the White House.
Correct.
So after he went to his safety, he later published that photo himself. So we are aware to what extent. Yes, I think these acts, sir, I think going a step further from what you said, yes, a beginning has been done. We are seeing that in at least two primary states, our neighbors and ourselves. It has to be, I think, gone down further as well. I do agree totally.
Thank you. Thank you, sir.
Thank you very much, sir.
Thank you, sir. Can we have the next online question, please? All right, I am unmuting Mr. N.S. Satyanarayan Gupta.
Thank you, Trivikram.
Thank you, sir.
Okay. Good evening, Mr. Amar, Korean.
So good evening, sir.
Good evening. Sir, you have taken us, we have traveled with you for the act. This is a contour. Now,
thank you very much.
Now let me say that this is all the celebrities, important people, politicians are very much connected to these activities. So the investigative agencies, they will not, they'll be not interested to investigate the case and to see a logical end in the matter. And lot of technicalities are there, they will not comply. On account of these reasons, they are not succeeding in getting the punishment to the accused. That is number one, question number one. Then yes, question number two is, what is your take about the yesterday's order of Justice Srinivas Harish?
Okay. So now the first question that you asked about the logical end of these investigations. So when it comes to trial of Ndps cases, sir, now I had the honor of appearing along with one of the senior counsels from Chennai Bar, Mr. B. Kumar, who is known to be a specialist when it comes to Ndps offenses, plus also preventive detentions. That was the case, sir, in 1998, where 30 crores worth of heroin was seized in between Sira and Tumkur. Now, like every other case, that case also had its technical flaws and even factual flaws, despite being investigated by a specialized agency, which is NCB. Now, the need of the hour, sir, is that there has to be proper training given to all the officers, including these specialized agencies, and definitely the local police are in need of training in investigation of these offenses from the very basics itself. That being absent, I don't think, sir, there would be any proper logical conclusion as such to this. Unfortunately, sometimes, yes, as I think being on the defense side, of course, as a defense lawyer, every defense lawyer, we would want to explore all these loopholes. All these loopholes, we will do it time and again. But at some point of time, yes, we do feel that there is no proper investigation. Now, your second query also, before your second query as such. Now, just one comment I would want to make on the present investigation in respect of, I think, the actresses being arrested, and for Ndpx offenses, they are in prison right now. At times I question myself, were these the only two actresses involved? did the investigating agency go through more deeper into it, and did they come across any other materials against other actresses, actors, and other people? And did they go and try to continue their investigation on those lines also? Of course, so that is a larger question. According to me, that will always remain a question mark. So I don't think we are ever going to see an end on that. But the present, yesterday's judgment as such a rejection of a bail. Now, to the extent I understand, there has been a seizure shown. Sorry, I did not have an opportunity to read the judgment as such delivered yesterday, because what I last read was that the full part of the judgment would be out very soon. This is what I read yesterday. Today, I did not go to the judgment. But at this point of time, sir, I think unless there is a prima facie case pointed out indicating reasonable ground to believe that the accused is not guilty, then in such an event, I would say it's not easy for the courts also to consider favorably the bail application. Now, like I mentioned, the Reha Chakraborty's case. Now, the Reha Chakraborty's judgment, initially she also suffered a rejection at the hands of the Bombay High Court. Subsequently, she was able to get bail. Now, the rigors of Section 37 of the Ndps Act were applicable in that case also. But what is the explanation the Honorable Bombay High Court gave there, or the reasoning given by the Honorable Bombay High Court was? Now, to the extent I remember, and even majority of I think the judgment there indicates the allegation against Reha was she had paid money for procuring of the drugs for consumption for Sushant Singh Rajput, her friend. Now, the Bombay High Court says there that Section 27A allegation, which is in respect of financing the illicit trafficking and also harboring. The Bombay High Court says that itself, paying money to an individual to procure drug for his own consumption. That is like I want to consume drug. I ask a good friend of mine, please give me money. Now, neither of us can be termed to be trafficking in drugs or harboring, meaning that for the purpose of consumption. So that is the explanation given by the Bombay High Court while explaining Section 37 here. So to that extent, I would say, as far as the High Court judgment yesterday is concerned, I am not very sure so much.
Of course, that may be a reason to grant the bail. That may be a reason. See, I know definitely that you are consuming the drug. In spite of that, I pay money to you. Then what does it mean? I am abetting you. Is it not an offense?
Abatement, yes, but that abatement does not come under the rigors of Section 37. If it had come, then yes, the bar would be applicable, because 27A was there. To that extent, the Bombay High Court has considered it.
Okay. Thank you, Amar.
Thank you very much, sir.
Wonderful. Thank you.
Thank you, sir.
Thank you, Divikram.
Thank you, sir. Can we have the next online question, please? I saw Mr. Ramu raising his hand. Can we have the next online question? I think that's about it, sir, for the day.
Good. Thank you, Vikram. Thank you very much. It's been a pleasure. We only gain in knowledge all through this. Thank you to all the attendees. Thank you very much, sir.
From our end also, sir, on behalf of Advocates Association Bengaluru, my sincere thanks to you for a very enlightening session, for a detailed discussion on the Ndps Act. Thank you so much, sir.
Thank you very much. Thank you very much. Thank you.
Commission now will be signing off today's session.
Great. Great.